You are listening to the Bell Post. Welcome to season 4 of the Bell Post. And today we're going to talk about a case. We always like and enjoy talking about new cases as they're coming out of the Court of Appeals that affect the bell industry. And today we're going to be talking about a case entitled United States versus Wayne D. Lozier. It's an important case from the standpoint of recovery agents and what you should do and what you should not do when you're going to different states to bring and to capture somebody or recover them and bring them back to your home state. On today's episode, our guest is a new friend of mine, someone that I've known for a year or so. And he's also an attorney, but he's from Kansas, and his name is Cal Williams. Cal, welcome to our podcast.
Thank you. Thank you.
I always like to research people who know watch our podcast and know I like to research. So I'll try to just Google you and find out as much information as I can. And I found out that you went to the Washburn University School of Law. You graduated in 1978. Talk about the Washburn School of Law. Were you legacy? Did you have other relatives that went there?
No, I wasn't a legacy. I have since had a daughter who went there.
Well, congratulations.
But I was the first, so to speak, professional in my family that I was aware of. Believe it or not, I went to law school on a dare.
What do you mean when you say that? A dare?
Well,
who dared you?
By the time I got to law school, I had been in college and wasn't able to keep my hours up. This is back during Vietnam.
Mm-hmm.
And you had to be matriculating at a certain rate or you were subject to being drafted. Well, after about 3 years, in which I only made 2 years worth of progress towards a degree, I got drafted and did my 2 years and came out and worked for a couple of years for Burroughs Business Machines back when they still did that. And then decided I wasn't good at that and went back to college. A friend who was going straight through, so he was substantially younger than me, wanted to go to law school. And he was from a little dusty town in Kansas. Their family lived baling hay. I mean, great guy, but a real hick. And we were drinking beer one night and he was telling me about his dreams. And I said, what makes you think you could ever get into law school? And he looked at me and he says, well, what about you? And I said, I don't think I could ever get in. And we ended up betting a case of beer on taking the LSAT, the Law School Aptitude Test. Well, I took it, and in those days, there was no preparation. You just took the darn thing. And I took it and scored well and got into law school and completely changed my direction. So it wasn't like it was a lifelong dream or anything like that. I grew up the child of an Air Force officer and moved around a lot and all of those kind of things.
I'm very similar, except not the military. My dad was appointed to the very first class of the Air Force Academy, but he failed his physical and they found out he was diabetic. So my dad moved around. He was a nomad for a little bit because, he was disappointed that he didn't get into the military academy or the Air Force Academy. But so he went to Hardin-Simmons University in Abilene and met my mom. They got married. They both dropped out of school, which they never admitted to us for many, many years. And they had 4 kids in 2 years and 5 months. And I was the second one. My sisters were twins and they were the third and the fourth one. They were 11 months after me. But the only reason why I went to law school is because I had this dream. My mom and I used to watch Perry Mason every Sunday night. And I mean, that sounds so silly now, but I mean, that was my dream, was to be law school. And, I was from a podunk town moving irrigation pipe in the peanut fields. And, it was not a goal, it was a dream. And so I had to figure out how to turn a dream into a goal and work really hard for it. Because, when you graduate from a small town, sometimes they don't really get you ready for college. They get you ready for life. And, there was 24 people in my class and we were all farmers. And so they were getting us ready for life. And so when I got to college, I was behind and I had to get caught up. And so that affected me when I was turning around applying to go to law school.
I know what you mean. I came to Kansas in 1962 from Riverside, Long Beach area out in California.
Oh yeah, that's where my wife was born, Riverside.
Well, my dad spent a lot of time at March Air Force Base,
Hmm.
and uh, ended up. My folks got into the business of raising greyhound racing dogs,
Wow.
and we ended up in Abilene, Kansas, because that's where the registry for it is. Um, Grew up doing that during high school and adjusted to Abilene, Kansas after Southern California. My mother asked me once, was it an adjustment? And I said, no, it was just like moving into an Archie comic book because it was kind of like Archie comic book compared to what Southern California was in those days in the early 60s. So, I'm a child of the 60s. I went through high school and started college in the 60s and finished up in the early 70s in the Army. But I think where we've been and what we've done shapes us when it comes to our beliefs and attitudes about the law.
I want to talk to you about three things about your law school experience. Number one, you've mentioned the importance of mentoring, and you graduates of Washburn University School of Law who've talked about you as being important in their lives as a mentor. But and also you've really stressed how graduates of law school can make a living and be important in small rural communities. Uh, how did you connect? I talk about how I feel like I connected with the Bell industry because we have blue collar values. We work really hard. But how did you
Mhm.
connect with the rural communities or the rural towns in Kansas?
It was an easy fit because I wasn't in a big city. Right out of law school, I was one county south of Topeka, which is a farm county. And I ran for county attorney there and became the elected prosecutor.
Oh,
Like
wow.
everybody pays their dues, and quite often in those days, at least when you came into a place.
Let me stop you there. I don't know if I've ever told this story, but I was in my third year of law school. I had a job. I was offered a job. It was in a big town job, but they offered me a job in Dallas or Tyler, and I went to Tyler because I was not a big city boy. But my dad was heartbroken because he wanted me to move home and live with them and run for DA of Eastland County. And I kept telling him, Dad, I'm sorry, but a 29-year-old guy right out of law school living with his mom and dad, his mommy and daddy is not going to be elected DA in Eastland County. So, I mean, talk about the transition. I mean, I would not have felt equipped. I wouldn't have felt competent to be the county attorney right out of law school.
Well, by the time I got out of law school, I was 30, had a wife and two children.
Wow.
And of course, she was working. And I was not a good law student. I was bottom of the class the whole way. I say they pried me out of law school with a shoehorn, and it's kind of true. But I just had a problem with blue books. You ask me a question, I'm going to try to
Yeah.
answer it. And I could
Yeah.
not wrap my head around the idea that instead of answering the question, tell the professor everything you know about the subject.
Yeah.
I, I'm a storyteller. I tried to stay with the story, and it didn't get me good grades, but it ended up paying off later.
The problem I had was I always did great after the first test because you got the feel for the instructor. And so but in law school, your first test is your first semester.
Yeah, yeah.
And so, I kind of learned a lot from that test or those tests, but I was in the bottom, I was right probably in the middle of my class. But at the end of the second semester, so the end of the first year, I mean, I was top 10% for the semester, but top third for one place below you could write on to law review. And so by then I was really clicking. So I got pissed. And so I did the really hard write on to law review. And then I hated law review because, I was wanting to do all the speaking contests. But I'm telling you, I mean, I took the hardest teacher or had the hardest teacher for legal writing. And I don't know why, but the first test he came back or the first writing thing came back, everybody was getting C's, D's. Then he handed me mine, and it was an A, and I was like, "Oh my God, I think I may have stumbled into being able to write legally."
That's the truth. That's the way it works. Well,
Well,
my name and law review were never mentioned in the same sentence.
ah, well, but I think you do though. You do understand the importance of mentoring and being mentored.
Oh,
And
yeah,
when
yeah.
when I went to law school, I think that's one of the best things going to a good sized law firm is being taught how to practice law. And when you're in a rural community, that I think that sometimes that's hard. So talk about the people. What did you learn through mentoring, and what have you passed on to others when you were mentoring them?
I was, when I ran for county attorney, I had been practicing there for 2 years. Uh, Little tiny office, just me.
Hmm.
Nobody would have hired me, but I hung a shingle and did what you do and stumbled along. But I managed to make friends with some old judges and such that something would happen in court. I'd go back into chambers afterwards and
Hmm.
just kind of lay my heart out on his desk and say, I don't understand this, or why do we do this way? And those judges in those smaller towns, more rural areas, they were understanding and they kind of liked being asked.
Yeah.
So it worked for me. And after about 2 years, I got to know a fellow real well who was about 10 years older than me. He had been a aeronautical engineer
Hmm.
and worked for Boeing in Wichita. And about the second time the plant went out on strike, he said, "That's enough of this. I've got a family to feed."
Yeah.
And as an engineer, he doesn't get strike benefits or anything. He's just not working. Um, so he went to law school at KU and got his degree. But he was in the county seat, which was about 10 miles from where I was living. We got to be good friends, and he and I couldn't have been more opposite.
Hmm.
I'm outspoken. I'm an optimist. I'm pretty liberal. He was the opposite of all those things. Uh, Yet we got along famously
Hmm.
because he would understand my point of view, and I would try to understand his point of view. And oh, we used to get in some great discussions, but they weren't knockdown arguments. They were just discussions. And, it's kind of like if you go to court and you've got a good attorney on the other side, the case is easier. Well, that's the way he and I were. I respected his intellect. He respected that I wasn't a legal scholar, but that I had pretty good judgment.
The guy that taught me to practice law, he's retired now, and he has some dementia issues, so he's quit practicing law. But he was like, I mean, I thought he was one of the best attorneys in East Texas, probably in the state of Texas, for doing defense work. And I give him the credit for really teaching me how to practice law. And I mean, when we would go to trial as a trial team, we would have a notebook full of issues that we had anticipated might come up. And so I would write briefs on all those issues. And if they didn't come up, fine, it was a waste of time. But if it came up, well, he would just turn to me and I'd say, yeah, we anticipated this issue. We have a trial brief on this, and here it is. And let me tell you what the issue is. I mean, we became very successful because of that, things like that. And but also, I mean, just like you, I remember probably with the first hearing I went to. I mean, I was still 29, but I looked a lot younger than I do now. But the judge looked at me and said, Mr. Goodwin, your dad gets here, we'll start. And that's so nice when you're when that happens to you. But I had another incident when like you said, something happens and you're there, and the judge is asking you what you're there for, and you're like, you have no clue. And I'm just like, well, Your Honor, this is what I'm here for. And he's like, oh God, we need to go off the record. And he's like, you can't do that. And so,
Yeah,
you
yeah,
learn really quickly. But one of the things that I did in the area I was practicing at the time, I reviewed all the Supreme Court cases from the Texas Supreme Court and looked for those issues. And so I became pretty good at picking issues and making issues if we're going to go to trial, so that if we had to appeal, we would have an appellate issue, and it was something that the appellate courts were in the midst of addressing, so that if we got screwed, then maybe we would have an issue that the Court of Appeals would like, and then possibly reverse the case. I mean, I was doing medical malpractice for a while, and I went to an appellate seminar, a seminar at med-mal, and they had a section on appellate cases, and 3 of the 6 cases were mine from doing that.
That's good. That's quite a compliment.
So talk about this intensive trial advocacy program. It looks like you've had a long commitment or involvement in that at the Washburn University School of Law.
Yeah, it's based on the NITA approach. If you
I
know
don't know
what
what that
NITA
is. So tell me what
Okay, National Institute of Trial Advocacy. And NITA is mean. You can't do anything right when you go into a NITA course.
Mhm.
And they will take lawyers out 5 years, 10 years, and have them come to wherever the NITA course is being taught. And the people running the course, they're just mean. If you can't think of anything else when you go to critique the lawyer, tell him to quit slouching
Uh,
or don't wear pink socks.
uh,
You never get a compliment at NITA
uh-huh.
until about the very end. It reminded me an awful lot of basic training.
Ah,
I mean, it's almost like drill instructors. But the way we did it with law school students, we tamed it down a little bit. But still, when we first started doing it, there was always somebody crying. I had girls start crying.
well, is it to
People
give them
just,
a taste to make them get into a courtroom or to know what it's like in a courtroom? Is that what the purpose
yeah,
is?
yeah, and that's what it is. But they have this case, and they're supposed to have read it and come to court, come to class the first day ready
Oh,
and put them on their feet. We're
uh-huh.
going to do a little bit of direct here.
Yeah.
And I get some guy up there who can't do anything,
Mhm.
can't remember the client's name, can't can't get anything right. And after about 3 minutes, I'm sitting up at the front with 2 other attorneys. We were actually in the appellate courtroom
Uh-huh.
of the law school. So there's 3 of us up there like a panel. And I finally just threw an eraser at him and told him to go sit down. And I kind of lost my temper a little bit because I said, when you can't even remember your own effing client's name, you're never going to make a nickel in this business, and we're wasting our time on you. And made him sit down. And the other 2 attorneys looked, I scared them. But
Oh
damn it,
my God.
I was trying to make a point.
Yeah.
If that's the way he would go into a courtroom when he's first out, he wouldn't live through it.
I had a professor my first semester, and that's what he did. And there was a girl, he would make you stand and he would quiz you, and girl fainted. And they had a couple of people, they took her outside and they splashed water in her face, but they brought her right back in, put her in her chair, and he said, "Stand up. Where were you?" And
Yeah,
that was,
yeah. I
in the
had a girl
80s.
do the same thing that all we were doing was going over how to get a photograph into evidence.
Oh yeah.
It's just 3 little questions. And she couldn't get the words right, she was just so nervous and so broken up. And I was trying to nudge her firmly, not too gently, firmly, but nudge her along. And she finally just broke down, started crying, and walked out of class. So I turned to one of the other attorneys and said, "Take over." I went out in the hall and talked to her.
Mhm.
And my daughter, that's an attorney, had only been out for about 3 years at this point. So I used her as an example to this girl. And I said, you're way too involved. Just relax a little bit, and you can do it easier. It'll come to you because it's not complicated. You're trying so hard, you're stumbling over your own feelings of inadequacy. Well, she came back in. She was okay. A year and a half later, because she had one more semester to go in law school, I think. But a year and a half later, I got a letter from her. She had
Oh
had the
yeah.
same thing happen in a courtroom in Lawrence, Kansas, in where KU is, and the other attorney couldn't get the item into evidence. And she she wrote this nice little letter, and she says, "Mr. Williams, I am just so happy that you made me do that because I saw what happens to people who don't know how to do it."
You know, I had an experience like that where I was trying to train a new associate on how to write appellate briefs.
Mhm.
And we went through a tough time on an issue where she didn't do as good a job on the brief, and the Court of Appeals noticed that she didn't do as good a job as she could have done. And I took it personally. I took it against our client. I took it. And so she ended up eventually leaving the firm and going to another place. But she wrote me a letter like that saying, because of you teaching me how to write an appellate brief, it really helped me at my new firm. And I wish, so it really kind of, it took, I was off guard when I received it.
Well, last year, the last time I taught, or maybe it was 2 years ago, I had a young man in the class, and I found out he was the grandson of the gentleman that had been my mentor.
Oh, wow. Grandson.
And I went up and I started talking to him, and then he recognized me as being a pallbearer at his grandfather's funeral. And I got to talking to him about his grandmother, and I knew his mother when she was in high school, who was also an attorney, and his dad's an attorney. But we were in a big group at that point, not just 8 or 9 students. We had the whole 150 students in there. And I embarrassed the poor kid because I went over and I put my hand on his shoulder and I said, you guys have listened for a week to me talk about get a mentor, get a mentor, get a mentor. Well, I want to tell you something. This young gentleman right here, his grandfather was my mentor. And a finer attorney I never knew, and a finer man I never met. Integrity, honesty, decency. And I said, I'm sorry if I embarrassed you by doing that, but it's real, guys. It's real.
I tell people that when you hire someone of our age,
Mm-hmm.
you're hiring us and you're getting the benefit of all the mistakes that we've either made or learned from over our long careers. And when you hire a new attorney, they have it. I mean, you can be and you will be one of those mistakes that they learn from. And I've really kind of, I mean, I hate to say it sometimes, but that's really true.
Young man I sold my building to when I retired, we had worked together for a while. We weren't partners, but we were sharing space. He rented
Sure.
space from me. I sold him the building. I When I was writing bonds for a while, which I don't do anymore, but I did for a little while, just for something to do. I wrote a bond for a girl that he was representing. He called me and I went all the way out to Colby to write the bond. And I gave her a ride from one county seat town to the next county seat town where she was meeting somebody. And as we're riding along, we're talking. And when we got to the second place, she went to get out of the car and she says, you tell almost the exact same stories Justin does. And I looked at her and I said, no, Justin's telling you my stories. But one crime at a time.
Yeah.
Don't get picked up DUI when you've got pot in your pocket, kind of things, and just silly things like that. But you're right, and he now has made those stories his stories, and he passes them on, and it's Ken. It makes me feel good.
Oh yeah, yeah, absolutely. Well, I know
That's
we're here
not.
to talk about a case, but before we do that, I
Yeah,
would love to hear more about your family. You've already mentioned that you were married with two kids when you graduated from law school, and
yeah.
your daughter is graduated from law school. I mean, my wife is also an attorney, so I mean, my wife is much smarter than me. We have two kids. Our youngest is a sophomore in college, even though she would tell you that she's got enough hours that she's a junior. So how dare you call her a sophomore? But talk about your family.
We have 4 daughters.
Wow.
They're all they range in age from about 55 to 43. The one that's 43 is a nurse practitioner,
Mhm.
and she and her husband have 3 boys. The next one up is the attorney. She and her husband, who is a captain in the Kansas Highway Patrol, have 3 girls.
Wow.
And then, 2 more daughters, each have 3 kids. So we've got 12 grandkids.
I am so jealous. I'm grandchildless.
Well, our oldest grandchild is 30, I think, or if not
Wow.
30, real close to it. And our youngest is 11.
Well,
So
as a father of girls, and I know you are a father of girls. I
four
mean,
of them.
there's, I mean, it's girls are different, and I love girls. I would not trade. I usually say that God gave me girls because He knew how competitive I was, and if He gave me boys, I would be on the sidelines of the football field yelling at the refs. But since He gave me girls, I was in the dance recitals taking videos, and I wasn't yelling at any referee.
I can't tell you how many dance recitals and things like that I went to, but they're all. My wife finally finished her degree about the time the youngest daughter was graduating.
Oh, really?
Yeah, but she was teaching, and she was actually teaching in a community college with a
Mhm.
bat with without her bachelor's degree when they hired her, but she got her bachelor's and then went right into working on a master's and
Sure.
got her master's, and about 5 years later retired. But she's got her master's. I've got my law degree, but all four of our daughters have at least two degrees.
Wow. Well,
Uh,
I mean, I
had a
can't.
reason for doing that, Ken. I
Why?
go back to my early years when I used to do a lot of divorces and things.
Hmm.
And I saw a lot of
Yeah.
women, I
Yeah.
saw a lot of men, and I saw how hard it was to maintain two households on two separate incomes when you can barely do it with two incomes together and it's one household. Well, I wanted all of my girls to, I'm fortunate, I've got four great son in laws, but I wanted each girl to be financially able to go out on her own and feed her kids if everything went to hell.
Yeah. Well, and that's my oldest is, graduated from Baylor. She's got a good job. She has a serious boyfriend. But I mean, I've always told her, you are a strong, independent woman. I mean,
Yeah.
I mean, she would quote me, I'm a strong, independent woman. But I mean, but yeah, understand. Well, you and I met, and we met because we, through a mutual friend, David Stuckman,
Mm-hmm.
and he put us on an amicus brief committee to give advice and to decide whether to file an amicus brief in this case called United States versus Lozier. And there was a lot of, I would say, trepidation, a lot of, I would say there was mixed feelings in the bail industry about whether an amicus brief should be filed. I mean, comment about that.
A lot of what happened to Mr. Lozier, he brought on himself. He could have prevented all of this from happening. And that's part of what scares me about the decision in this case. I am so happy for him that it got reversed, that he's going to get another shot at it. And I understand there is going to be a second trial. I was hoping they would decide it wasn't worth it, but I would imagine that the prosecutor's ego is bruised. So,
Well, but let's set this up. So, what we have is a bounty hunter who is licensed in the state of Louisiana. I think in Louisiana, you are a bounty hunter if you are licensed as a bondsman. So but someone was acting as a bounty hunter and he was licensed to do so in Louisiana. And someone missed court, and another bonding company hired them to recover the person and bring them back to court. There was a valid warrant issued. But the problem is the person went to the state of Missouri and was staying with someone they met in drug rehab. So they met a friend, so they were staying with them. And so this incident all arises from the recovery agent, Mr. Lozier, going to the state of Missouri with his, I guess, partner. Um, and his partner's name was Sullivan. And so Lozier and Sullivan went to the state of Missouri. They went into this house. They were not licensed under Missouri law. They didn't contact local police and let them know they were going into this house. Got this person, put her in their car, and then started traveling back to Louisiana. The local police were contacted. They actually eventually we're talking to him on the phone. They were talking about whether he should be doing this, whether he made a mistake, and they were trying to get him to drop her off at a police station. And they decided not to. And they crossed state lines. They went into Mississippi. They decided maybe they made a mistake and dropped her off at a jail in Mississippi, and did not take her all the way back to Louisiana. And so if there was a mistake, I mean, okay, so you're in Kansas. What do you tell your recovery agents that are coming to Kansas from another state? Can someone from Texas come and do recovery in Kansas?
I'm not sure.
Yeah. I mean, that's the whole problem. It all depends on
I
the each
think
state's laws.
my attitude was always, I'm a belt and suspenders kind of guy.
Uh-huh.
Um, Even here in Kansas, when I'd go out to get somebody, if I thought there was going to be a problem, I'd go to law enforcement first.
Yeah.
Um, I remember one time I thought there was going to be a problem, and I just flagged down a highway patrolman who was coming down the street, and I got him to help me because I told him who my son-in-law was that was his captain. So he came and he
Oh
sat
yeah.
in his car out in the street and watched just
Mhm.
to make sure there wasn't,
Yeah.
didn't go to fisticuffs or anything. And it turned out the person wasn't there. But I have picked up people and turned them in, but always by them volunteering to go with me. You
Nowadays,
can,
even if they volunteer, you want to put it all on video because you don't want them to change their
yeah,
mind and suddenly say false imprisonment.
you come with me, you sit in the front seat, no handcuffs. We drive to the jail, we get out and walk in, and I will turn you over to the jailer. But it's all above board. Now, you don't want to come with me and you want to be crazy? I will send someone to pick you up. They
Mhm.
will cuff you and stuff you, and you're not going to like it. So, what you missed court. I know you missed court. Just come with me and we'll try to get
But
this set
one
up.
of the things that this issue raises is something I don't think the public realizes. And we always think as when the bonding community is writing a bond that it's a riskier bond the more, the heavier the charge. And that is once you get to the really bad stuff. But if we're just talking about a low-level felony versus a misdemeanor, a lot of times we say that misdemeanors are riskier bond if they don't have any ties to the community because once they get out of state,
Yeah,
most states won't bring them back. And so it's very difficult to force them to come back once on a misdemeanor when they leave the jurisdiction.
I wouldn't write a misdemeanor bond for somebody from out of state.
Yeah.
I would go talk to the judge. But having been a defense attorney and a prosecutor, I can do that. I'd go over and just talk to the judge, talk to the prosecutor, and say, look, this guy's out of state. You want him sitting here for 45
Yeah.
days or 60 days or 90 days on your ticket
Yeah.
and running up those costs? Let him go. If he comes back, fine. If he doesn't come back, issue a warrant that lays there forever.
Well, and so in this case, we've got, if we have violations, and I know we've already talked about, a lot of the issues that maybe that occurred here were brought on by the recovery agent being just a little bit too aggressive. Because we
Mm-hmm.
always tell people, are you licensed in the state or have you checked to see if there's a requirement in the state for licensing? If there is, then you got to comply with it. And so the first thing out of the bat is this recovery agent was not licensed under Missouri law. He did not notify them they were going into the house, which is a requirement of of Missouri law. But the problem is, even with all those deficiencies, Missouri just declined to file any charges on the recovery agents.
That's a point that has always bothered me about the feds picking this up.
Mhm.
I can't help but think there is some underlying reason for this case becoming what it became because it was allegedly state laws that
Mhm.
he violated by picking the person up without have taken a cop with him. So why didn't if it was as serious as they claim, why didn't the state prosecute?
Well, and I think for our industry, our concern was since the state declined to file charges, but the federal government stepped in, and they stepped in because he crossed state lines with this woman. They filed federal kidnapping and conspiracy to kidnap charges
Yeah,
against both the recovery agent Lozier and his partner. And so the case turned out to be: is this federal kidnapping?
I think the case actually turned out to be much ado about nothing.
Well, I don't know if we can say that because I
Oh,
still
I know
think,
we can't say that,
I mean, we can't
but
say that because it's going to go back to trial, but let's see how
sure,
we got
it's
there.
but
So,
that's what disturbs me going
yeah,
behind the motivation for the
yeah,
federal government to bring kidnapping is akin to murder. It's
Oh,
way up
yeah,
there.
way out
Murder,
there.
rape, and kidnapping.
Yeah, I mean, it carries
And
substantial length of incarceration, and so I mean, I think from our, I mean, look, when I was first contacted and told about this case, I was saying, oh, the bond, I mean, the recovery agent wasn't allowed to even tell his story. He wasn't allowed to say he was licensed in Louisiana. He wasn't allowed to say there was a warrant. But all that turned out to not be true.
yeah,
He was
yeah.
allowed to offer evidence of every bit of that. The problem was once all that came out to the jury, the judge cut the knees out from under him on his on his theory of the case through the jury instructions.
Yeah. And that was the thing that bothered me from the get-go. When I was at the oral argument,
Well, let's
it
don't get
was
there. Let's get there because when we were talking about whether to file an amicus,
mhm.
the jury instruction what is actually what tipped me to say we should file an amicus. What was the determining factor on you for you to say we should file an amicus?
Same exact thing.
Well,
But I think
and
that
why is
goes
that? Why was
because
that?
we're lawyers.
Oh yeah, because I mean, when we look at appeals, there's different appeals, there's different issues, and some of them are just you're never going to win that issue. Abuse of discretion standard. But when you start talking about the jury charge, the judge either did it right or wrong, and so you've got a shot, a better shot on an
And
appeal.
as it turned out, that the court actually got to where I was hoping they would get to, and I'm sure you were too, a de novo review.
Yeah. Yes.
All new.
All new because it was a question of law. Because I mean, the federal law is a little different than Texas law on the issue of a jury charge. Because in Texas, I'm not sure there's a harmless error standard. If the judge is wrong on the jury charge, he's wrong. But I don't know if it's a really big difference because under the opinion that was written, I mean, I don't think the standard's that much different. If the judge is wrong on the instructions he gives to the jury, that's a de novo review. It's a question of law. Uh, and so, we recommended that an amicus brief be filed. We gave input on the filing of it. And I was just noticing that in the Court of Appeals opinion that they issued, underneath the style of the case, it says Professional Bell Agents Association of the United States, and then Turning Leaf Inc. Amici brief of appellant. I thought that, I mean, I don't know if I've seen that in Texas where they list the amicus on the style of the case. So I
Yeah,
don't,
I found that to be a little strange too, but kind of nice.
oh yeah, yeah. So talk about, you went to the oral argument. And so you have an insight that I don't have.
Two things became apparent at the oral argument. Uh, Number one, you ever sat through an argument where maybe it was the other side getting ripped, or maybe it was the side you support getting ripped,
Mhm.
but the way the judges are doing it is so harsh that it just makes you uncomfortable to even be sitting there?
Wow.
That's kind of the way one of these three judges went after the appellee.
Oh, the United States government?
Yes. And
Well,
there
what
was
kind of
two,
questions was he
well, it was
asking?
two things. There was two issues. One was the jury instruction,
Mhm.
but the other more subtle issue was between the judge and the lawyer. And apparently there was some history there that I didn't know about, but it was you are trying to take a mashup of state law and
Mhm.
federal law and mix them in such a way that you can't lose.
That's exactly what happened because under the
And
federal
the
statute,
judge called him on it.
well, under
He took him apart on it.
the question, the issue was whether the taking was unlawful. But under the case law, unlawful had, two elements. The first element is he acts contrary to the law, and two, he acted without justification or excuse. So
Mhm.
the argument was that, they were saying, did he act in an unlawful way? That's Missouri law. But was it justified or with excuse because of a valid warrant? He was licensed in the state of Louisiana. And so they ultimately argued that the judge cut out his ability to argue justification or excuse through his instruction. But how did that come out in the oral argument?
It was strange. It Dave didn't follow it at all. I explained it to him later because he was asking me because it was so intertwined. And you've seen when a judge gets right on an attorney and the attorney's trying to fight back. It was it had to do, and the judge used the phrase mash up, if I remember correctly, of how you're trying to have your way on this law here with a state interpretation, but yet you want to come over here and use the federal interpretation to support a different view or a different part of it. And then you want to mash them together and say the judge had no choice. This
Yeah.
is the way it had to be.
Mm-hmm.
And uh, the prosecutor really got raked over the coals in that.
Well,
And
they should have, because I question
yeah,
whether any bail recovery. I mean, think about the politics for a moment. If any recovery agent who crosses state lines is going to be at risk for federal kidnapping charges, that's going to impact the industry as a whole across the nation. Insurance companies are not going to be able to hire or employ recovery agents to go across state lines.
absolutely. But the court didn't ignore the fact that the recovery agent could have avoided all of this by simply going to the police station first with his paperwork.
Yeah.
And that leads me to wonder, Ken, you drive into a town, you're going to pick somebody up. You go by their address first just to make sure you can find it. Then you go to the police station and an officer follows you back. Well, what if when you're going by it the first time, the guy's out there loading his car, got a suitcase in his hand?
Yeah,
You
but
stop.
what we fail to remember, I think the practical aspect that we forget about is we go to the police station and we say, I've got a warrant. I know right where they are in your state. And they're like, well, that's a freaking misdemeanor. We're not going to take them in because they're not going to extradite a misdemeanor.
But if it is a felony,
Yeah,
and
but let's stay here. I mean, so if this was a misdemeanor case, and I mean, they would not have arrested her or taken her into possession. When he dropped her off in Mississippi, when he got out of Missouri and Mississippi, she wasn't extradited. She fought extradition and they ultimately released her on another bond. And she ultimately went back on her own to Louisiana. She never
what
got
I've
forced to
seen
go.
happen, and I've seen this happen, is like you're describing. You go to the police and they say, "Well, it's just a misdemeanor. We're not going to mess with it." And the bondsman or the recovery agent says, "Well, I want to go pick her up."
Mhm.
And they says, "Well, go ahead. Just don't violate the peace."
Yes.
You know, kind of like peaceful picking up a car for the bank. Under the UCC, you don't violate
Mhm.
certain things. And if you can talk them into coming out and getting in with you, and you drive back, you're fine. But what happens when there's a problem?
Yeah.
And that's what happened here. You say they wouldn't have gone. Well, we don't know. And that's the part that bothers me about this.
That was what was causing problems for the industry about
Right.
whether to file an amicus.
And I just don't want coming out of this people in the industry of recovery making the supposition that, well, we're okay. We got the Lozier case on our side. Well,
Oh, yeah.
no, you
No,
don't.
because all they got on this case was a new trial.
Yeah. You
I mean, they found that the jury instruction was improper, that it gutted his ability to argue evidence of excuse or justification. And so he gets to go back for a new trial on, and really we're going to offer all the same evidence. We're just going to change the instruction and allow an element of justification or excuse to be argued before the
I
jury.
had a similar situation in California
Mhm.
during COVID. I found the guy. I knew where he was living. It was a felony, but I couldn't get anybody to go get him. The whole country was still in lockdown.
Mhm. Mhm.
And so I got the judge to give me a Zoom hearing, and I explained what it was, but I put in my brief all the steps I had to go through in California to abide by their law.
Mhm.
And if I didn't abide by their law, I was guilty of a misdemeanor. And I had to, subject to a fine of up to 15,000 or something. It
Mhm.
was ridiculous.
Yeah,
So I go to the judge and I said, I'm on your clock counting down. I'm on their clock. If I do want to pick him up, I've
sure.
got to stay in California long enough to set up a hearing, attend the hearing, do this, that, and the other. And I said, this is just crazy, Judge. Here's where he's at. Here's his address. I guarantee you he's there. He's living with his brother. And the judge said to the prosecutor, he says, "You think the sheriff's office wants to go out there and get him?" And they said, "No, I don't think so." And the judge, I mean, this is all on Zoom. And I looked over at the judge and he looked at me and he says, you're off the bond, Cal.
Well, and
But
we really need more of that, especially
yeah,
with Trump administration is going to be doing with illegal immigrations or illegal immigrants. We're gonna have people out on bond in Texas that have holds on them, and they're going to get deported, and we're going to suddenly not have a defense to a bond forfeiture.
right. And we better find a way around that.
Hmm.
I would maybe I should suggest to Dave that they put something together and hire a couple of guys like you and me to study this and come up with a,
Yeah.
a paper, a
Yeah,
white paper.
a model statute. In
Yes,
California, if
yes.
they're deported and the government doesn't want them, then they can't go forward on the bond forfeiture. But we're not ever going to get red states to enact a California statute.
Oh no, no.
We've looked at the opinion, and because of the jury's instruction, this is what the judge said: a rational jury could have found Lozier's actions were justifiable or excusable because he was authorized to seize the defendant as an agent of her bondsman. The jury could have concluded that him seizing her pursuant to the warrant and the bond agreement was justifiable or an excuse. And the jury was not allowed to consider that. And so that was they, why they concluded the instruction was improper. It was not waived. It was not harmless error because of the beyond a reasonable doubt standard. So they had to find that they would have found him guilty beyond a reasonable doubt, even with that instruction, and they said you couldn't. And so they reversed the trial court's judgment, told it, remanded for a new trial, and said don't use that instruction again.
Well, to me, it's simply the judge invaded the jury's province.
Yeah, that I think that's
And
the easy way to say it. I agree.
yeah, and once you ask for a jury, once you've got a jury, the judge's involvement is limited by some fairly strict rules. I don't know that much about federal, but I assume it's very similar to most of our states.
In this case, the partner pled guilty and got probation. But he ended up, and I think the reason why the bail industry got involved is because of a kidnapping statute based or charge based upon acts that the state declined to prosecute. The recovery agent got 10 years in the federal
Mhm.
pokey, which is, it was a downward deviation from the recommended sentencing. So he got less than he could have gotten. And that would just seem so egregious to the bail industry, I think.
I think the prosecution could have worked their way out of this,
Mhm.
even after the decision was made. Go to the defense and say, let's just call this time served.
Well, I think they still could, but I'm worried that the bondsman or the recovery agent is thinking that he can't plead guilty because that'll affect his licensing. But
Yeah,
I
and that's
don't.
probably true.
Well,
But
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 but it didn't keep his partner from pleading, so I don't know.
yeah, part of what bothers me here is you see no movement from the Appley side, the states, the government side, towards settling it in a reasonable fashion. Now, if they came to me with that offer, I'd say, well, no, because of course, I do what the client wanted, but it affects the license. But at least it would be a start.
Oh yeah.
Open up some talk, because it appears to me in reading appellant's brief that they tried, that the attorneys were trying They're out in the hall talking. They come up with a joint definition they both can live
Sure,
with, and
sure.
the judge refuses it.
Yeah, I think that, but the judge decided to just cut the legs out from under the bondsman because he tried
Yeah.
his whole case one way, and the judge said, "No, you can't consider that in the instruction."
And so I see part of this opinion as being a slap at the judge to
I do too.
not take it out of the province of the jury,
I do
and
too.
then a slap at the poor prosecutor who had to go in there and argue the judge's position when it was really actually happening. That wasn't where he was.
Well, I also thought, I mean, my perception from talking to you about the oral argument is also, I think there was a little bit of a problem from the appellate judges saying, why are we punishing the recovery agent for doing their job on someone who has a warrant and who has failed to appear for court?
Yeah,
Why are we trying to turn that into federal kidnapping?
kidnapping. Yeah. And that's kind of what that federal judge, and it was the one who wrote the opinion that was doing most of the talking. That's kind of part of what I was getting. You read between the lines. I read between the
Sure.
lines when these guys are talking up there. And that was what I was getting. Of course, I walked out of there. Dave's saying, well, surely we're going to win this. And I said, they may find a way to hang him yet because I've seen it happen.
Yeah, yeah. Well, and the harmless error thing was the backdoor way to affirm,
Yeah.
and they didn't do
Yeah.
that. But I've had a couple of oral arguments. I've had a lot of oral arguments, but I've had a couple that stick out in my mind. One of the first ones I did was before the Fifth Circuit, which is the equivalent. And I was a young attorney, and I was up there on a throwaway case. But the judges were so smart, and they were just playing games with me. And I don't like to play games. And I finally just looked at one of these judges who's been there forever, who has a great reputation, and I'm like, Your Honor, I don't even know what you just said. So I don't know how to answer that. And but my thought is get them laughing. But I
Mhm.
had another oral argument where I researched that panel and I knew exactly which judge was going to be against me. And I researched all of his opinions that were on similar issues. And I had convinced the other side that I was going to lose because I got up there and I started explaining how there was a case exactly on this where the court ruled the exact opposite direction of the way I was asking them to rule. And all the people on the other side in the room started laughing, thinking I'd lost my case. And then I pulled the rug completely out from under them and said, but in your opinion, you said this is what's missing. And in my opinion, my case, it's all over the place. I mean, and it worked out so well. It was like a Perry Mason moment.
Yeah.
I
Yeah.
that I mean I you could hear them gasp, and I won that thing unanimously. And so I've been on both ends of the spectrum on that. Uh, but what do you think the future holds for this case? I mean, is it just we're going to retry it or unless they settle it?
I think if it gets retried and the state doesn't, or the prosecution doesn't soften up a little bit, uh, I think it's 50-50 chance of being
Yeah.
acquitted.
Well, I think it could be the exact same result.
Yeah.
There's the risk of that, but they could also say that he had an excuse and he was justified.
Yeah.
But when we get to this 50-50 roll of the dice, flip of a coin, I always come back to we're bondsmen. We don't start on an equal footing with people. And so it's not a fair roll of the dice or a flip of the
I
coin.
don't know how many times I've, three or four that I'm sure at least, where I've been in front of a judge, probably in chambers, arguing for an excusable neglect.
Sure.
You're right, Your Honor. I was supposed to have it here Friday. I got tied up. I missed it. I was here at 8 o'clock Monday morning and filed it. Best I can do, Judge. I'm sorry. And sometimes I win, sometimes I lose.
Well, I don't like to predict what the court is going to do on our podcast. I love to
Mhm.
write articles about what has happened, especially at the Court of Appeals level. But this case has a lot of risk to the defendant. It has substantial risk. I mean, he could get retried, and the judge could, if he got found guilty, the judge could give him a longer sentence. And sometimes they would do that in this situation. But, he could also be tried and be acquitted.
I think one of the things I like about the case is that it recognizes the federal abuse of due process at the state level.
Mhm.
And this was that mashup of the laws
Yeah.
that they took him to task on. And I wasn't following it. When the judge started in on this on the appellee, I wasn't following it. And I listened and I thought, and then it dawned on me what he was talking about. The mashup, you want the best of both
Yeah.
worlds. And you've got to pick your poison. And he made him pick, and he found out. But
Okay.
it's a
So,
great outcome for Lozier, considering where he started.
well,
I mean, he's not the best guy in the world.
what do you think the chances are that I mean, because I think part of this is political. I mean, I
Oh
think
yeah,
it became political. They did federal kidnapping because the federal government is kind of anti-bail. And so they were sending a message to recovery agents. And I think there was a lot of politics here that there shouldn't have been. But what do you think the chances are? And this may just be very low, but I think there might be some chance that the new Trump administration may set different priorities. And this case could become lower on their priority list and it could go by the go away maybe.
I think there is a chance of that. I agree. The old law and order Republicans isn't who we have anymore.
Well, I
Uh,
mean, a law, and that's the way I look at this. A law and order state would look at this and say the recovery agent made some mistakes, but they were acting in good faith. They had a warrant and they had a contract and they were just taking that person back to court. And that person had failed to appear. That person had run to another state, contrary to what they promised the court, contrary to what they promised the bondsman. And so I think that those issues should be left to the states to decide. And if they say no, we don't want to get in the business of the other state on their criminal laws, we think that was okay. He screwed up, but it's not one that we should punish. I think we should go with that.
yeah, I agree. We just we don't know what's going to happen after yesterday.
But we've got to get politics out of this kind of crap. We
Yeah.
don't
Oh,
need
absolutely.
a recovery agents to be worried about politics. We don't need the next presidential election. I mean, we are now at the point where Trump, his inauguration was yesterday. He signed 100, 200 executive orders. I mean, we now spend the
You
first
mean
week.
amending the
Yeah.
Constitution by executive order?
Well, we now spend all of our time undoing everything that the last administration does. And we never used to do that before Obama. Now we do that all the time. So we've got to get to that. Cal, I can't tell you how much I've enjoyed talking to you. I enjoy talking to you about legal issues because I think you and I think a lot alike on those issues. But this has been a great conversation, and thank you for hitting this back and forth with me and educating our industry on this important issue.
Well, I hope so, because I think a lot of this was just you and me BSing with each other because we do think alike.
Thank you for listening, and come back for the next episode of The Bell Post.